we're going to be speaking today about UK immigration, what's new and how to stay ahead. And just to say what we'll cover here. So we're principally, Jess, can we have the next slide? We're principally going to be talking about the sponsorship management system. And I think many of you who are joining us are going to be familiar with this already. We're going to talk about sponsorship licenses, your obligations as license holders and employers, and the key considerations you'll need to bear in mind. What changes that have recently come in and will be coming in shortly in the next few months, what changes professional practices generally and license holders generally need to be aware of, what action needs to be taken around your license and around these changes, and how you can prepare for those changes. And generally, we want to address how you as license holders and employers who employ non-UK nationals, how to navigate this area, how to address those changes, and give you practical advice about how to stay ahead, for example, in relation to changes that we're going to see coming in, for example, with right to work obligations that you have. Next slide, please. So just to give you, this will be familiar to those of you who are sponsorship license holders already, but the overarching principles of sponsorship should be always borne in mind, because they need to be taken very seriously. I mean, sponsorship basically is based on two main principles. And the guidance, which will be again familiar to many of you, does state that sponsorship is a privilege, not a right. And indeed, that'll be upheld, that has been upheld by the Supreme Court. And it means that those who benefit most directly from employing migrant workers must play their part in ensuring the immigration system isn't abused. They need to ensure that they comply with the wider law and not behave in a manner that's not conducive to the public good. When we talk about compliance with wider UK law, we're really talking about employment law, obligations, minimum wage, obligations as regards planning permission and similar. And overseas nationals who apply for permission to enter or stay in the UK to work are eligible to do so, so long as a trustworthy and licensed employer genuinely wishes to employ and sponsor them. And that genuineness is something that needs to be taken very seriously, because when a sponsor is granted a license, a significant level of trust is placed in them. And with that trust, the Home Office say there is a direct responsibility to act in accordance with the UK's immigration law. And all parts of the sponsorship guidance underlines that. So that's what we'll be focusing on. And in particular, we'll be talking about sponsor duties, and those include that your duties as licensed sponsors to report, to keep records, and ensure that you understand what key personnel as named on your license, who they are, what their responsibilities are, and important considerations they need to bear in mind. And I'm talking there about the authorizing officer, the key contact, and the level 1 and 2 users. So we'll talk about the reports, what needs to be reported and when, what records need to be kept, and the effect of any recent changes. I mean, actually not that recent. As you'll be aware, there's now no longer, and hasn't been for the last couple of years, any requirement for people to advertise a position. There's no more resident labour market test. But instead of that, are you under any obligation to provide evidence to the Home Office? And if so, what that is. We'll also talk about compliance visits, what to expect from those, whether they happen in person or just by getting emails from the Home Office, and that's happening more and more frequently now, and how you can prepare for that. And my colleague Yawar will talk about top tips and the HR considerations you need to be borne in mind. I'm conscious I haven't actually introduced my colleagues, apologies for that. I'm going to be speaking here with Adèle Standard, who is a senior associate in the team, and Yawar Abbas, who's also an associate working with us. So Yawar, can I hand over to you? Next slide, please, Jess, to talk about the ongoing reporting and compliance duties that are placed on sponsorship licensed holders.
Thank you so much, Sasha. So as a licensed sponsor, you as a business are required to report certain events to the Home Office within very specific timeframes. of that event taking place. Usually that time frame is 10 or 20 working days, depending on the nature of the event. These reports have to be made by the level 1 user who has the access to the sponsorship management system. But as I will explain a bit later on as well, ultimately it is the authorizing officer who is responsible for making these reports. These compliance requirements remain in place even if there are very few or no sponsored employees. I've given some examples below of the kinds of events the Home Office will need to be informed of when they relate to sponsored workers or if they just relate to change in businesses. So with regards to sponsored workers, if there are any changes to their employment, such as job title, their job duties, if they've been promoted, if there are any salary changes or changes in hours of work or pace of work, these will need to be reported to the Home Office. Further examples are unauthorized absences, for example, of consecutive 10 days or more. If there's a failure to report to work, or usually if there is termination of employment, where sponsorship comes to an end as well. This is not an exhaustive list, but it gives you an idea of the kind of HR events, the kind of events which need to be informed to the Home Office within specific timeframes. Can I have the next slide, please? Thanks. These requirements, the business changes, these are ongoing, even if there are no sponsored workers. These need to be, again, reported to the Home Office. And examples are if there is change in name, branches, if there are changes to any contact details, details of key personnel. Again, I will come to that as well. Or if there's any change of structure or the size of the business as per Companies Act. One thing which must be borne in mind here is that if the business is subject to a merger or a takeover, or if there's immediate change of ownership, we need to keep in mind that a sponsor license is not transferable, and in which case a new license will need to be applied within a very strict time frame. So this really does pose challenges, and we have to really sort of act in a good time to ensure that if there are any sponsored workers, they're able to move to the new license in appropriate time. So it's always a good idea to review the status of the license at least once a month. Whoever is the authorizing officer or the level 1 user should be doing that once a month. They should diarize that to see whether the details are up to date, and to see whether sort of any reports are required to be made. As I say that, it's the level 1 user who has access to the system, but ultimately it will be the authorizing officer who is responsible for meeting these requirements. So it would be a good time now to review these key personnel in place as well. Slide, please.
Thanks, Yawar. I wanted to ask you, what happens when things go wrong? For example, if a sponsor license holder doesn't comply with these obligations, what can happen then?
So the Home Office have several enforcement options at play. As you mentioned earlier as well, the Supreme Court has confirmed that a sponsor license is a privilege and not a right. So these reporting and compliance requirements need to be adhered to strictly. Non-compliance can lead to risks of revocation of the license, suspension, and even downgrading, which broadly means that you might be prohibited from hiring and sponsoring any new talent. And it could also, in worst case scenarios, mean that you'll have to bring the sponsorship and employment of already existing sponsored employees to an end, meaning that their right to live and work in the UK is terminated. There's also obviously the reputational damage as well. Home Office report these revocations in public domain, so this information will be available publicly. So you'll have to consider reputational damage as well. So it's quite important that these reports are made in time, and that the authorizing officer and the key personnel, which are the level 1 user and the authorizing officer, and they are aware of which reports need to be made and in what time frame.
Next slide, please. Thanks, Yawar. And I just want to turn to Adèle now and ask about some of the changes that are coming in, and some that have come in already and some that we're expecting. Do you want to tell us a bit about that, Adèle?
Yeah, well, a number of new routes have been introduced into the immigration rules. Many of them are essentially just a rebranding of previous categories, but some do offer new options for bringing people into the UK. Of note are the already open global business mobility category, as well as there's also the new high potential individual and scale up routes, which are due to open later in the year. Importantly, there have been significant changes to how right to work must be checked. Can I have the next slide, please? In respect to the new routes that are already in effect, the global business mobility route is designed for businesses seeking to establish a presence in or transfer staff to the UK, and it opened on the 11th of April this year. To a large extent, it's just a rebranding of the intercompany transfer and sole representative categories, but there are some differences. Under the umbrella of the GBM, there are 5 categories: senior or specialist worker, graduate trainee, UK expansion worker, service supplier, and secondment worker. Professional services firms may already be familiar with the requirements of the senior or specialist worker category, graduate trainee, and the service supplier routes, as they're simply a rebranding of the previous ICT, graduate trainee, and temporary worker international agreement routes. There's therefore not much to note in respect of changes, other than the salary threshold to qualify for the ICT, or now named senior or specialist worker category, has increased to 42,400 a year. So it still holds very little benefit over the skilled worker category. And despite its rebranding, I think it's unlikely to attract many applicants, as the salary and the skills threshold is higher than for the skilled worker category. The application fees are pretty much the same, and the route doesn't lead to settlement. Only where meeting an English language requirement could be an issue, or where a salary is mostly made up of guaranteed allowances and bonuses, could this be beneficial over the skilled worker category, which isn't often applicable to people being transferred to the UK by professional service firms. Also under the GBM, the UK expansion worker route is a reinvention of the sole representative category. It's for senior managers or specialist employees who are being assigned to the UK to undertake work related to a business's expansion to the UK. Unlike the sole rep category, more than one employee from a business can be under the route at the same time, up to a maximum of 5 people. But the category does now require the business apply for a sponsor license before employees can apply under the route, whereas under the now retired sole representative category, this wasn't the case. So businesses will need to identify key personnel to be responsible for the license and comply with sponsor duties and obligations as licensed sponsors, as Sacha and Yawar have already discussed. So there are additional obligations early on for that route. The sponsoring company must have been actively trading overseas for at least 3 years. It must not have an existing active trading presence in the UK, but it must have a UK footprint. So UK footprint would be evidence of business premises or registration with Companies House. A credible expansion plan must also be submitted with the application. So this route would be useful for overseas professional service firms who don't yet have a presence in the UK but want to expand into it. So UK expansion worker applicants must have worked for their employer outside of the UK for at least 12 months if they're earning less than 73,900 a year. They must be in an eligible role and meet the minimum salary thresholds, which are at least 42,400 a year, and the appropriate rate for their job. As part of an economic partnership agreement with Japan, Japanese nationals are exempt from the requirement of working for 12 months for their employer. The business must establish a UK trading presence within 2 years of people being in the UK under that route, or the sponsored workers under the route will not be able to extend their stay, and the sponsor license would be at risk of revocation. So there's also the secondment worker category under the GBM. It's a new route for workers being seconded to the UK as part of a high value contract or investment by their overseas employer. And high value for these purposes means an investment or a contract worth at least £10 million per year and no less than 50 million overall. Applicants must have worked for their employer for at least 12 months outside the UK and be in an eligible role. And permission is granted for up to 12 months with the possibility of extending for another 12 months.
Next slide, please. Yeah, and Adèle, do you want to tell us a bit about the new high potential individual route as well?
Yeah, well, so there are two new categories that are due to open later this year. That's the new high potential individual route and also the scale up visa. The new high potential individual route is due to open on the 30th of this month, 30th of May, and will somewhat plug the gap left when the historic Tier 1 general category closed to new applicants in 2011. The Home Office describes it as an elite points-based route to attract the brightest and best in the UK to maintain our status as a leading international hub for emerging technologies. Applicants must have a bachelor's or postgraduate degree from one of the top 50 global universities outside the UK, and that must be awarded in the 5 years preceding the application. Permission under the category is granted for 2 years for those with a bachelor's or master's and 3 years for those who have a PhD. And applicants must meet an English language requirement. They can bring family members. This is a useful category for firms looking to recruit the best overseas talent without immediately committing to the duties and fees associated with the sponsor license and sponsorship. Can I have the next slide, please? So the scale-up visa is also due to open later this year on the 22nd of August and enables those with a job offer from a recognised UK scale-up to qualify for a fast-track visa. To be recognised as a scale-up, you must demonstrate that you have an annualised growth of at least 20% for the previous 3 years before the application, and that's 20% growth for either turnover or staffing. You must have a minimum of 10 employees at the beginning of the 3-year period you're qualifying for. And the government has said that it will consider in due course additional requirements which may be met to qualify in future. So for those who don't meet the current requirements, there may be options to qualify later down the line. The job offer must be skilled to graduate level and pay an appropriate salary for the job, as with most categories. And the minimum salary must be at least 33,000. Permission is granted for 2 years with the possibility of extending for a further 3. And after 5 years, you'd be eligible for settlement. Interestingly, scale-up migrants are only tied to their sponsoring employer for the first 6 months of their permission. After that, they can work for any employer at any skill level. And so to qualify, they have to meet an English language requirement, and they can also bring family members if they want to.
And Adèle, are you going to talk to us about the right to work changes that I think some of which have come in and what we can expect in the coming months?
Yeah, so generally, employers must check the right to work of all their employees on or before their first day of work. And historically, this has required employers to check original right to work documents in the presence of the employee. But the pandemic brought more Home Office functions online, including right to work checks. And as we were told to stay at home and work from home, employers were unable to check right to work documents in person. So this prompted the Home Office to introduce a concession to right to work checks, where they could be carried out by video call and by checking electronic copies rather than originals. That concession has been extended to the 30th of September of this year. However, the Home Office, seeing how well online checks worked and remote checks worked, has now, for the most part, moved right to work checks online to the in-person checks of original documents are no longer permitted for some. That means that the extension of the coronavirus right to work check concession doesn't apply to those who hold a BRP, biometric residence permit, a biometric residence card, or a frontier worker permit. So from the 6th of April of this year, employers can no longer correctly check right to work via a physical BRP, BRC, or frontier worker permit for most non-UK nationals. Therefore, the Home Office online service must be used to properly check right to work. You don't need to carry out retrospective checks on existing employees using the online system. but you do need to carry out online checks rather than checks of physical documents on or before the first day of work for most non-UK or Irish nationals. So employers should therefore, if they've not done so already, update their internal onboarding processes to align with these new rules. Other forms of physical document that evidence right to work other than a BRP or BRC or frontier worker permit can still be used to correctly check right to work, such as passports and immigration status documents. But employers must still hold a video call or meet the employee in person when carrying out the online check. Only physical documents are required for online checks. There is a new service whereby British and Irish citizens' right to work can be checked online. Theoretically, it's been introduced by the Home Office. Through this process, employers can use third-party service providers to carry out the right to work checks digitally on their behalf for just British and Irish nationals. But the third-party provider must be chosen from a Home Office list of certified identity service providers. And so far, it was open 6th of April. So far, no providers have been certified yet. So in practice, this service can't be used.
Thanks, Adèle. I thought we would then just talk briefly about business travel to the UK, because obviously people travel in and out for brief visits, and we just want to think about the limitations on visitors post-Brexit. And I wanted to ask Yawar, what are those restrictions, Yawar? Can you talk about that?
Sure, thank you, Sasha. With professional services clients, we regularly see partners, senior employees, or actually associates, etc. as well, employees traveling to the UK to meet with clients and conduct meetings here. So speaking with regards to business travel to the UK, there are only very specific activities which are permitted under the UK immigration rules. So just as an example, individuals can't be seen and cannot advise clients and cannot be seen to be conducting work in the UK. Meetings are, however, permitted, and internal meetings are permitted as well. So it's essential that individuals, when traveling to the UK, carefully see what the purpose of the visit is and whether it is permitted under the visitor requirements. Usually, a couple of practice points to keep in mind are that if an individual travels very regularly to the UK, would it be beneficial to have a work permit issued for them, permitting them to undertake a broader range of activities, even if they're not living in the UK? And the second thing to keep in mind is the frequency of travel. If those individuals are traveling very frequently, it's very likely that the border force officials will question whether those individuals have in fact relocated to the UK or if they're conducting work. So top tip in that sense is to carefully analyze the purpose of the trip, consider whether a work permit would be more appropriate. If not, then usually a comfort letter is quite helpful as well, which details as to why the visit qualifies qualifies under the business visit rules.
Thanks, Yawar. And I thought I would just quickly address the idea of travelling into the EU from the UK, because particularly for UK nationals, going to the EU is not as straightforward as it once was following our departure from the EU. So obviously before January 2021, the freedom of movement applied. So UK travellers didn't need to think about permission to travel to the EU or work there. So now, with the end of that freedom of movement, immigration rules in the UK as well as the EU have fundamentally changed, and business travel is no exception to this. Obviously the pandemic hid some of the impacts of Brexit because people weren't travelling as much, if at all. But the fact remains that the legal landscape's changed a lot, and there's increased complexity and compliance risks for both UK and EU nationals. So just travelling into the EU, there are two sets of relevant regulations to think about here. One, the Schengen rules, as well as country-by-country immigration rules. So the Schengen area, which will be familiar to most of you, obviously removed internal border controls between those nations signed up to it. Obviously, the UK and Ireland are not signatories of the Schengen Agreement. So British nationals are exempt from applying in advance for a Schengen visa, but not importantly from the time limit on the time spent in the Schengen area. You're allowed as a UK national or any non-Schengen area national to spend a total of 90 days in any rolling 180-day period in the EU. And that 90-day period applies simultaneously for tourism and for business trips. So if, for example, you have a 5-day business trip with a 10-day holiday, this counts as 15 days in the region. So 15 days of your 90 days in any rolling 6-month period. Calculating your Schengen allowance does require some mental gymnastics and an up-to-date calendar. You should keep an up-to-date calendar because the 180-day period is constantly rolling. So do remember and account for all your travel. And I appreciate that can be challenging for a lot of business travelers. And it's important because overstaying that 90-day rule is a potential that if you overstay it, there is a potential for a bar on entry to any Schengen area country in the future. But assuming the Schengen rules are complied with, the next hurdle is the individual country's internal immigration rules. And previously, as I said, freedom of movement allowed a UK national to do anything across the EU, including starting work on the same day as they arrived. Now, UK nationals are limited on the whole to visa-free entry for tourism and for business activities, but you do need to be careful and think about what those business activities amount to. I mean, what count as business activities as opposed to full-on work? This is left up to each member state to decide. The rules on what counts as work can, and they do, vary across the EU. I mean, for example, a UK national can visit Italy to conduct an internal audit without having to get a visa, but they would require a work permit to carry out audit activities in Spain. And there are helpful country by country guides that the Home Office have produced to assist business travellers. And there are industry and country specific exemptions, but the point is just that they're exemptions to the general legal position. And worth mentioning here, the Trade and Cooperation Agreement signed at the end of 2020 between the UK and the EU specifically does allow professional advisors to travel into the EU. It provides some protection for short-term business visitors and business travellers performing company establishment activities, and it also allows intra-corporate transferees to go in to the EU. But there are still several country-specific restrictions for business visitors. And it's worth, as I say, ensuring that you understand what any particular country's rules require of business visitors before travelling. I mean, some of the general activities included in the Trade and Cooperation Agreement are very similar to the kinds of business visitor activities in UK law. For example, you can go to the EU as a UK national without having to get a visa to, for example, attend meetings, consultations, you can go for research and design, you can attend training seminars or trade fairs and exhibitions. You can even undertake commercial transaction work. So, for example, management of personnel or financial services personnel engaging in commercial transactions. All of those people can travel without having to get a visa to do so under the terms of the Trade and Cooperation Agreement. Final thing worth saying is probably that there are no Schengen or national immigration rules to worry about for trips to Ireland. The Common Travel Area ensures free movement for British and Irish nationals moving between those two areas. Next slide, please. So, Yawar, I just wanted to ask you now just about industry trends and the impact of the Ukrainian crisis on the Home Office and the resultant delays. Can you tell us a bit about that?
Sure. So the Ukrainian crisis has had an overall knock-on effect on the Home Office. The bottom line is that the Home Office are prioritizing all applications from Ukrainian nationals over everything else, over every other application. This has resulted in substantial delays all over throughout the system. This has also resulted in the suspension of priority and super priority services for applications being made from outside the UK. Some of you might recall these services where we would pay extra fee for a decision to be made within 1 or 5 working days. So these have been suspended, and even where the Home Office are saying that they'll make a decision, let's say for a work permit application in 15 working days, the fact of the matter is that they are taking much longer than that, and in some cases even double that time. In fact, the Home Office have just today issued a further notification saying that work visas are taking substantially longer. Just to stress on that point, the family applications, so spouse visas, etc., they are taking about 24 weeks to be processed. We don't expect this to improve anytime soon, given the staffing levels at the Home Office and the backlog. So this will continue. And our top tip is that any moves to the UK are planned well in advance, with plenty of time. And if possible, there should be some flexibility in plans as well. It's also a good idea to manage expectations of applicants and clients, etc., in view of these delays, so that they are aware that things might not always go to plan, especially these days. Besides the delays, another housekeeping matter is the fact that the Home Office are emailing level 1 users who, as I mentioned earlier, are considered key personnel and have access to the sponsorship management system. So they're emailing those level 1 users who have not logged into their system for the previous 12 months, and they're granting those level 1 users 10 working days to do so, so that they can ensure their details are up to date, and ensure that all the housekeeping is in order. So now would be a good time to for all level 1 users to log into the sponsorship management system to ensure that details are up to date. Next slide, please. And finally, there is some respite for those who are making applications from inside the UK. In some cases where those individuals who have existing biometric residence permits, the BRPs, they can now utilize the completely online process for applications. So which means that everything can be done online, and they do not need to visit the application center to provide their biometrics. Priority and super priority services are not yet available for these, but it does mean that it saves those applicants from quite some hassle. For employers, as my colleague Adèle said earlier as well, this means conducting the right to work check using the Home Office's online portal. So as an employer, you'll need to be aware of that as well.
Many thanks, Yawar. So that concludes what we wanted to speak about. And by all means, feel free to ask any questions using the Q&A buttons on the system. And we've had a few questions in, which I'll deal with now. Yawar, perhaps this is one for you. We're asked, generally speaking, due to the delays, how long is it taking for a skilled worker, the work permit process from the start to finish? How long is it taking?
Sure. So I'm currently advising that, pragmatically speaking, employers and individuals should keep 3 months in mind from the time they made an offer to their move to the UK. This is bearing in mind that they might need to meet English language requirements. There might need to be an assessment of their eligibility, issuing of the cause, etc. There's certain circumstances about situations we might need to analyze about partners and children. So that issuing of the cause, submitting the applications, attending an appointment, and then the delay in the processing period. And it is only after that that they're able to move to the UK. I would think that actually 3 months is what employers and applicants should keep in mind from the date they made an offer to them moving to the UK.
Thanks, Yawar. And Adèle, we've had someone ask, how do you check the right to work for someone who has a 90-day entry visa, but their biometric residence permit has not yet arrived? What do you do in those circumstances?
Well, you can check the right to work through via the entry visa until its expiry. As it's endorsed in the person's passport, it falls under the Home Office list of accepted documents for right to work. It's only BRPs that the physical document can't be checked. If the BRP hasn't arrived by the end of the 90-day period, you'd need to submit an employer checking service request to verify that they have the right to work until their BRP arrives, and you can check their status through that. The reason why you need to wait for their BRP to arrive before you can check their online right to work is because you need their BRP reference in order to do that. And the employee should also, if their BRP doesn't arrive, it hasn't arrived within the 90-day period, which is not that uncommon, I'd suggest that they report that the BRP hasn't arrived via the Home. There's an online form that they can report that to, and they'll get an update from the Home Office as to when they can expect it.
Thank you, Adèle. And one other question we've had in, now that employers aren't required to advertise a position before hiring someone into the business, this is sponsored license holders, obviously, what do you need to do or provide in relation to new hires? So I'll just deal with this. So even though you're not actually required and there's no set procedure to follow in relation to the resident labour market test, you do need to confirm that you've advertised the role, whether you've done so. In fact, you'll be asked about that at the time. If you apply for a sponsorship license, you'll be asked that, you know, how you came to wish to employ that particular person. You'll be asked about it, as I say, when you apply for a sponsorship license, and you could be asked at any time thereafter when you make a certificate of sponsorship or a work permit application. You'll be asked, you know, how have you identified that person? Why are you taking them on? So it's a good idea to retain details of any ads you have placed in the past. So keep a screenshot, a printout or a photocopy. Make sure you have access to and can confirm where the ad was placed. Keep records of who applied, the number of respondents, and I would always recommend keeping at least one other item of evidence which shows the process you've used to identify the most suitable candidate. But that might be, I don't know, interview notes, notes on why that candidate was selected, information on scoring or a grading process if you've recruited them via the milk round, the details of that, and evidence of previous successful performance if they were already working for you. Keep all of those things in hands, because you might well be asked to provide that at any time that you make an application for a certificate of sponsorship. So that just about concludes where we are and the talk. And if you've got any other questions that you'd like us to answer, please do feel free to email them to us or put them into the Q&A box. Happy to get back to you. Many thanks for joining us today, and yeah, all the best.